Very good morning to all of you. Today we'll be continuing our discourse on administrative law principles, right? In the last video, we discussed the definition and the nature and scope of administrative law. Today we'll be discussing or we'll have a discussion on what are the factors responsible for the evolution or growth of administrative law. And we'll be discussing this particular topic with a special reference to India, of course, but simultaneously we'll be discussing uh, evolution of administrative law in UK, United States of America, New Zealand, and Australia, right? Now, for that matter, just to begin with, just look at this slide. Just a bit of recapitulation what we did in our last class. Just to revise it, need to understand the very idea of administrative law, right? Now, I told you that it is a branch of public law which essentially is anti-authoritarian. It means that it is a completely contrary to arbitrariness or tyranny. Rather, it is a dharma of administration, right? Basically, what administrative law does is it basically, uh, basically it sets restrictions on bureaucracy. It sets restrictions on executives. It it demarcates a boundary line within which the entire administrative authorities and executives they are supposed to function within those jurisdiction fixed by this particular area of law, right? Basically it enforces reasonability, it enforces procedural fairness, it imposes non-arbitrariness, right? And basically it is a medium through which a type of synthesis is created between power and justice, because bureaucracy, it goes for using more and more powers, but simultaneously it is the people which are very important, and proper governance is very important. And executives and administrators, they are supposed to create a condition wherein the people they may live their life uh, with justice. They may lead a life with proper dignity, and this will give meaning to the right to life that is there in Article 21 of Indian Constitution. So, right. So in that context, let us understand the various conditions which actually compel or which created a condition wherein this particular branch of law emerged, right? Now, firstly, we need to understand that we have few pillars of democracy system, or and I mean three pillars where which is required for ensuring a life with dignity. Now in that case, the first is, of course, administrative justice. Now, a philosophy ensuring that the fundamental rights and interests of the individuals are rigorously safeguarded during all decision-making process. Now, for that, you need to have a proper administrative system wherein the fundamental rights and interest or personal liberty of individual is properly safeguarded, right? Secondly, the very idea of good governance or good administration, right? It's all about acceptance of certain accepted standards of administration, which focuses on rationality, which focuses on fairness, which focuses on consistency, and of course total transparency. Then we have another section that is executive accountability. The entire executives, they will have to accountable to for their every act of omission and commission. So this is very important, right? Now, these are the three pillars of good governance, and this is the reason we need to create a conducive atmosphere wherein all these three pillars are actually get sets, right? Now, moving our discussion further, let us try to understand the other areas here. Now, I'll be focusing on modern welfare state. I told you that right now in 21st century, we are in welfare state, right? A welfare state means the state is supposed to provide each and every conditions wherein the people, they may live their life with dignity. I mean, it is a duty of the state to provide basic essentials which is required for in an individual's life, or which is actually required, or to create an ecosystem where the individual may live a meaningful standard life, right? Now, what are the factors which actually contributed to the growth of administrative law? We're discussing this topic, right? Now, The first is judicial inadequacy. Now, traditional courts are a bit slow, they are formalistic, and they lack the technical expertise required for complex socioeconomic and industrial disputes. So, this is one of the factor here. Judicial inadequacy. We are talking about the traditional courts, right? Then legislative inadequacy. Now, as far as parliament is concerned, legislative assemblies are concerned, Vidhan Sabhas are concerned, they basically lack time. They lack flexibility and technique to draft the highly detailed, adaptable daily regulations required by a modern economy. See, the parliament, I mean, I don't doubt on the capabilities of the parliamentarian, but at the same time, we need to understand that they are not technically expert people. Now, the ground level people, the field level people, they are in better position to come up with certain rules, regulations, and documents. So they are in better position, or they are well versed with, I mean, they can feel the pulse of the people in that way. So they are in better position to come up with, the rules, regulations, which can better fit to the modern day complexities or requirement which is actually there. Then third is need for preventive justice. Regular courts punish after the fact, right? After the act is done. Modern state requires rapid preventive interventions when it comes to licensing, rate fixing, or safety enforcement before the act is actually done. So when it comes to preventive justice, it is the administrative system, administrative law, which has scored much as compared to the traditional courts. Now, some other factors like philosophical shift. Of course, we did this abandonment of laissez-faire. Citizens now demand government solve their problems from cradle to grave. Now they want the association, or they want government to interfere into their each and every aspect, each and every facet of their life. So in that case, there has been philosophical shift from laissez-faire state to welfare state. Now, another important point is inadequacy of the judiciary. I told you about the traditional courts, right? They are a bit slow, they are a bit costly, and they rely much on evidences. They much rely on lot many formalistic rules and regulations. So in that case, it is administrative law which doesn't rely much on them. So decision becomes quite faster. Action becomes quite faster, which actually people require. Then legislative constraint, we have already discussed this point. Then moving to another one, flexibility and experimentation. Now, experimentation can be better done in administrative law rather than legislative or parliament. You can do bit of experiment like through ordinances or executive orders or bylaws or through notifications. Uh, let's take an example of Kejriwal. Delhi government came up with the idea of odd and even. Or similarly, lot many experimentation can be done by district collector or superintendent of police. They come up with certain notification. Now, when they feel that, I mean, everything is going fine, they will continue with those notification. And when they feel that something is going wrong or people they are not accepting it, they can withdraw it. So experimentation can be done better through administrative law rather than the laws made by the parliament. Then we have preventive measures, of course. Prevention is better than cure. It's rightly been said. So preventive measures can be better taken care by administrative laws rather than the laws coming from the parliament. Then, of course, coming to post 1990 India, in special context to India, we have lot many state actors. We have lot many non-state actors which are actually playing vital role in our life. So in that context, their regulation is very much required. For that, administrative law basically talk of regulatory bodies or boards and commissions or different statutory committees set up by the parliament to look into the or to regulate into the non-state actors, which is actually required, right? Because India being a naive democracy, so some sort of regulation is very much required uh, to those people, right? Now, coming to Ajay Hasia and airport authority cases, you must have read this, particularly with reference to Article 12 of the Indian Constitution. It establishes that every instrumentalities or agency of the state is subject to fundamental rights and every action must be reasonable and non-arbitrary. So this is the idea which has, in fact, that was a turning point wherein the entire government or the parliament, they realize the fact that to somehow we need to create more and more of agencies or instrumentalities of the state, so that the people may be able to use their writs properly, because in that case most of our laws, most of the laws which are coming, which are actually regulating our life, they are coming from the chambers of bureaucrats rather than they are coming from the parliament. This is very important. We all need to understand. I repeat this. The most of the rules regulations which has an impact in our daily life, they are rather coming from the bureaucracy. They are coming from the chambers of bureaucracy rather than they are coming from the parliament. So in that context, that is something which is very important. Now, moving further, coming to some of the mandates here, like just look at Article 38, Article 39, 41, 45, 47 of Directive Principle of State Policy, which mandated social justice, living wages, and public health. Now, this has to be this is the aspiration of the state. So in that context, this can be only fulfilled with the help of the executives, with the help of administrative authorities, and thus the importance of administrative law. Then judicial check, Article 32, Article 226 of the Indian Constitutions, Article 311, protecting civil servants from arbitrary dismissal, Article 300, government tortures liabilities. So, and of course, Article 323A and 323B, which talks of, some sort of administrative tribunals. And it has been constitutionally mandated to come up with the tribunals, because tribunals are the bodies which are quite technically expert, and they can deliver the justice in shortest span of time because of the expertise they have. Then coming to another section here, like judicial control through courts, then Lokpal, ombudsman, or Lokayuks in the states, then higher administrative authorities reviewing the action of the subordinates, right? So these are the different mechanism which are in fact one of the wings of administrative law, which are able to create a conducive condition, so that the people, they are in position to enjoy their life or enjoy a meaningful life. So that is only possible with the growth of this branch of government, this branch of law. Now, I have compared this administrative tribunals with that of traditional courts, particularly if you look at the Ramanna, the Ramseti versus International Airport Authority of India. I mean, the state's exemption of industrial and commercial activities means citizens constantly encounter state power holders. So the very idea is to regulate the authorities. The very idea is to come up with certain mechanism through which the administrative powers may be regulated, may be controlled, and this can be only done through administrative laws, right? Then just to compare with the United Kingdom and United States, how this administrative law actually emerged. Now, if you look at A.V. Dicey, initially he was not in favor of coming with certain some sort of administrative tribunal in United Kingdom, because he felt that this the tribunals which exist in France is to somehow is a denial of the rule of law. But later on, with Denagmore Committee and Crown Proceeding Acts, uh, which comes up with an idea that the king can do no wrong. I mean, that shatters the myth which was actually believed in Great Britain, and simultaneously the idea of delegated legislation came into being. Similarly, if you look at United States of America, I mean, this administrative law is considered as a fourth branch of the government, right? And particularly in 1930s, we saw the New Deal creates massive administrative agencies. In 1946, the Administrative Procedure Act is passed to legally regulate and control this explosive agency's growth. So in that context, we can see how the administrative law has actually emerged in most of the countries, particularly after Second World War, the one who got independence after Second World War, right? Now, just comparing with Australia and New Zealand here, just look at this particular committee. 1971 CARE committee recommended a completely general system of administrative law. Then they had in 1975 administrative appeal tribunal, right? And then 1976 Ombudsman Act and 1977 Judicial Review Act. simplified procedures, and established new institutions of control. So more or less, we can see how these this branch of law is gaining, or in fact, is gaining momentum day by day, particularly with the challenges which the state they are facing right now. And most of the states in the world, they have now turned into administrative states. Similarly, the case of, the New Zealand, particularly 1962, I mean, the first common law country to adopt the Scandinavian system of ombudsman. Then they have administrative division of the Supreme Court created to promote specialization and expertise among judges, bringing greater consistency, coherence, and authority to administrative decisions. So, uh, so the very idea is to ensure good governance. The very idea is to ensure, better administration to the people. This idea of, providing people with the best of ecosystem where the people they may uh, feel comfortable, right? So in the next video, we'll be discussing uh, the different aspects of administrative law, and how the administrative law they have actually they have actually uh, gaining momentum in time to come, right?